Welcome to another BOV Fund Services podcast. Today we will be discussing the General Data Protection Regulation. Joining me today we have Dr. Chetcuti Dimech. What is GDPR? To whom does it apply? And how does it affect collective investment schemes?
The General Data Protection Regulation, as you said, known by its acronym GDPR, it will come into force in the EU member states on the 25th of May 2018. It replaces the previous Data Protection Directive and it's designed to harmonize and enhance privacy rules in the European Union and to protect and empower all EU citizens' data, privacy, and to reshape the way organizations deal with data privacy. It applies to all organizations within the European Union, and definitely it would also apply to Maltese collective investment schemes. Well, and if you had to compare the GDPR with the cast of a film, okay, you could say that there are four main characters. You have the data subject, who is the individual about whom the data is held. You have the controller, which is the entity that possesses the data and determines the purposes and conditions and means of processing of the data. Then the third character would be the processor, which is the entity that processes the personal data on behalf of the controller. And finally, you would have the Data Protection Authority. Data Protection Authority is the entity within the EU member state that enforces the regulation. Now, if you could compare these four characters in a fund setup, you could say that the collective investment scheme or the fund would be the controller, okay? The fund administrator would be the processor because it's handling data about the fund's clients, okay, to perform its duties, to process subscriptions and redemptions and keep the shareholder register. And the data subject then would be primarily the fund's investor, okay, but it also extends to other individuals about whom the fund has personal data, employees, board members, investment committee members, suppliers, they are individuals. And finally, you have the Data Protection Authority, which in Malta is the Information and Data Protection Commissioner, or IDPC.
Personal data is an important concept within GDPR. What is personal data?
The meaning of personal data is very wide. It comprises information related to a natural person that can be used to directly or indirectly identify the person. It can really be anything from a name, a photo, an email address, bank details, posts on social networking websites, an IP address, and even cookies, you know, these little pieces of information which we leave on our computers whenever we visit a website. So when you apply this now to a fund setup, okay, when you consider that for know your customer purposes, you know, the large amount of personal information which is collected about investors, there is no doubt that a fund is sitting on a lot of personal data which needs to be protected.
What are the main highlights of the General Data Protection Regulation?
The first point one could mention is that the conditions for consent for processing have been strengthened, you know. So you need to ask for the consent for processing in an intelligible and easily accessible form, you know, and the purposes of the processing needs to be clearly stated in using clear and plain language, you know. You can't simply put the consent in a vague manner. It has to be clear in the documentation. And when we refer to documentation, a fund would obtain this consent in the subscription form. Now, of course, GDPR also retained the possibility of processing without consent on the request of the data subject. So there are instances where, for example, an administrator is being asked to process a subscription or process a transfer or a redemption. You could say that the consent is already implied, okay, because it's the data subject that is requesting it. However, if the fund then is going to use the data for any other purpose, obviously this consent, additional consent, needs to be obtained. Another aspect of GDPR is that the data controller can be asked by the data subject to provide a confirmation whether or not personal data concerning them are being processed, and the controller has to provide a copy of that data free of charge in an electronic format to the data subject. Other areas is the right to be forgotten, which is a novel feature of the regulation, and also the question of data portability. You know, there is now the possibility that you actually request the controller to give you your data, and you can take it away with you and give it to somebody else, to another controller. But I think one of the things which is a significant development in GDPR is actually that there are severe penalties for breaches. The organizations in breach of the GDPR can be fined up to 4% of annual global turnover, or 20 million euro, whichever is the greater. So you immediately realize that, you know, the fines can be huge. Of course, the largest fines will be imposed on the largest breaches. Okay, so however, it's a significant development in GDPR. And finally, I should also mention that the GDPR emphasizes the concept of privacy by design. This means that organizations should implement data protection safeguards while designing systems rather than fixing them later with an add-on for data protection. And of course, controllers need to process only that data which is necessary for their duties. Okay, this is the principle of data minimization.
What responsibilities will data controllers and data processors have under the new regulation?
Okay, so the core themes of the GDPR, of the data protection principles in the GDPR, remain largely unchanged when compared to the directive. Okay, of course, there's a new principle of accountability which has been introduced. However, the core principles on data protection have remained the same. So personal data needs to be, first of all, processed lawfully and fairly and in a transparent manner. It has to be collected for specified, explicit and legitimate purposes and not further processed in a manner which is incompatible with those purposes. It needs to be adequate and relevant and limited to what is necessary in relation to the same purposes. It has to be accurate and kept up to date. And it also has to be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the data is processed. And also, the processing must meet appropriate security standards, technical and organizational standards in the processing of the data. Then the accountability principle which GDPR added to these core principles is that the controller is responsible and has to demonstrate compliance with these principles. GDPR, when compared to the previous data protection directive, also regulates data processors directly for the first time. So processors themselves will need to comply with a number of specific obligations, including to maintain adequate documentation, to implement security standards themselves, appropriate security standards. There's an obligation to carry out a routine data protection assessments, impact assessments. They also need to appoint a data protection officer. We'll speak about that a little bit later. And they also have an obligation to comply with the rules on international data transfers. And of course, cooperate with the national supervisory authorities. So when a controller is going to appoint a processor, you need to be careful to have a written data processing agreement is in place, which complies with the GDPR requirements. And because processors will be directly liable to sanctions if they fail to meet the principles of the regulation. And you could also have private claims by individuals for compensation. So when you apply this to a fund setup, you know, the fund would be delegating to the administrator the processing of the data. And so a fund would need to verify that the administrator systems are sufficiently robust to deal with the GDPR requirements. And you also need to look at the administration agreement and make sure that these principles and obligations with respect to data protection are appropriately catered for in the administration agreement or in an addendum to the administration agreement.
Did the regulation bring about any changes with respect to the notification of breaches?
Yes, of course. It's, I think, one of the most profound changes of GDPR, which is a European-wide requirement to notify data breaches to the supervisory authorities and even to the affected individuals themselves. So the rule is that without undue delay and where feasible not later than 72 hours after becoming aware of the breach, the controller, the processor, has to notify the breach to the supervisory authority, and the processor is required, obviously, to notify the controller without undue delay upon becoming aware of the breach. And there are requirements what the notification needs to contain. Here in Malta, I would provide the notification to the Information and Data Protection Commissioner. So where possible, you have to include the categories and the approximate number of individuals that have been impacted by the breach, the name of the data protection officer or any other contact in the organization, the likely consequences of the breach, and most importantly, what measures have been taken to mitigate the harm which could be caused by the breach. So when you apply this to a fund setup, and the fund would typically appoint the administrator to handle the records, it's important to ensure that the administrator reports breaches to the fund's board or to the fund's compliance officer without undue delay, and that the fund itself then would provide the notification to the Information and Data Protection Commissioner.
Does a collective investment scheme need to appoint a data protection officer?
Well, not always, it depends. So the appointment of the data protection officer is mandatory only for controllers and processors that have core activities which consist of processing operations which require regular and systematic monitoring of data subjects on a large scale. So you also have certain special categories of data that require that you have a data protection officer, and you also need to have a data protection officer if you're processing data relating to criminal convictions or offenses. So a typical fund, you know, especially with a small client base, would not need to appoint a data protection officer. However, if you have a fund with a shareholder register running into the thousands, you know, you would be considered as processing data on a large scale, and you would need to have a data protection officer. There are also requirements in the regulation on the data protection officer himself or herself. So he may be a staff member or an external service provider, and more importantly, he needs to have expert knowledge on data protection law and practice.